And now we're joined by attorney Liliթ Կարապետյան, an expert in investment law and arbitration and partner at Connцեռն Dialogue law firm. Good evening, Ms. Karapetyan.
Good evening.
The government pledged in its program to make Armenia an attractive destination for foreign investment. However, in 2024, the country experienced a negative net inflow of total foreign investments, approximately $291 million, while net foreign direct investment stood at $115 million. Against this backdrop, the government adopted a law on the nationalization of the electric networks of Armenia, enacted by direct order of Prime Minister Nikol Pashinyan. In such a context, can the protection of investors' rights truly be upheld?
Thank you. Thank you for the question. In order to answer this question, I want to take a step back and explain what is the legal climate that investors look into, what are the legal issues that the investors look into before they decide to make an investment in a country. One of the key issues for the investors is to have a specific expectation of how the country, how the place where you are investing in is going to treat your investment. And if not the first, but one of the first issues that the investors look into is how the state, how the legislation of the state treats the foreign investment. And the states, besides their national legislation, what they do is they enter into bilateral investment treaties. I'll be calling these BITs for the purposes of this question. And they conclude these BITs between two countries, which indicate specific protection mechanisms, protection standards for the investors. Particularly, Armenia, I believe, has 42 BITs concluded with 42 countries, which means that when an investor from, say, Cyprus comes to Armenia and makes an investment, then Armenia, under this BIT, will undertake to protect the investment, to provide certain protection mechanisms. What is also very important is when an investor from Armenia goes to Cyprus, the other contracting party, then the Armenian investment would also be protected in Cyprus. This creates a special level of guarantee, to call it so, for the investors who understand that when a national of one country comes to another country, they will have certain protections. So what kind of protections we're talking about? Expropriation is one of the key protection standards that the investors from foreign countries are given in Armenia and in whichever country the BIT has been concluded. Expropriation protects the investors from a theoretical scenario that an investment made in the country, in this case Armenia, will be illegally nationalized or expropriated. Because obviously the investors want to have a guarantee that when they make an investment, then their investment will not be expropriated. Now, coming back to your question, the key issue that we have here in this situation is that investment has been made by a Cypriot entity in Armenia, whereas right now we're talking about explicitly calling it a nationalization, expropriating the investment that has been made in Armenia. This gives a huge red flag for any investor who is considering coming to Armenia, because the first thing they're going to see is not a country who has a very, very legitimate, very, very good climate for investment, including legal climate, but is going to see a country which adopts a legislation which basically expropriates the investment and the proceeds from this investment that has been made in Armenia. So we will find, I'm more than sure, we'll find ourselves in a very difficult situation when investors will not even, let's call it this way, Armenia will not even pass the first stage for the investors when they're considering coming to Armenia, because this gives them the reason to see Armenia as a country which expropriates investments, and obviously decisions to make an investment in Armenia are going to become much more difficult.
Recently, the Stockholm Arbitration Court ruled in favor of the owner of the electric networks of Armenia and imposed an urgent measure restricting the Armenian government's actions until the issue is resolved. However, the Armenian government has effectively refused to comply with the decision, stating that it is not subject to enforcement as it has not been approved by an Armenian court. Ultimately, who is in the right? And what consequences could Armenia face for failing to implement this decision?
Again, thank you for the question. Who is right? That's the question. Look, again, taking a step back, I want to make it clear what this whole arbitration, emergency arbitration, what the process is. In my answer to the first question, I talked about BITs, the Bilateral Investment Treaty. So this BIT does not only indicate the protection mechanisms, for the investors, but it also indicates, okay, what happens when the BITs are breached, when the country where the investment has been made is breached. And it indicates, among other things, that when there is a breach of the BIT, a foreign investor can bring a claim against the state. Now, I want to draw a line between commercial arbitration and investment arbitration. Commercial arbitration is more or less more famous, and commercial arbitration is an alternative dispute resolution mechanism under which the parties, two private entities or two private persons, can decide that, say, they have an agreement. If there is a breach from this agreement, then the dispute will be referred not to a court, a traditional form of dispute resolution, but to an arbitrator. This is a standard commercial arbitration. This is not the case here. Here, we're talking about investment arbitration. Why? Because this is not an arbitration that is arising from an agreement between two private parties, two private entities, but this is an arbitration that has arisen from a bilateral investment treaty concluded not between Electric Networks of Armenia and the Republic of Armenia, but it is a agreement between two countries, a bilateral investment treaty. And here, the parties have agreed to refer the dispute between the investor and the state, not one organ of the state or one authority of the state, but the state, to arbitration. This is a classical example of an investment arbitration. So the Republic of Armenia has concluded this agreement. And under this agreement, it has been told that the dispute can be referred to Stockholm Institute of International Arbitration, International Chamber of Commerce, if I'm not mistaken, and ICSID, the International Court for Settlement of Disputes under the World Bank. So Stockholm Arbitration Center is one of the centers that has Armenia has agreed that the claims against it can be referred to. Even though Stockholm Arbitration Institute is traditionally a private, institution that solves the disputes between, of commercial arbitration, the example that I brought before. But it also resolves the disputes of investment arbitration. So now that we set the line that we're talking about investment arbitration and not the commercial arbitration, what is very important to highlight here, between the lines of the response that I saw from the government of Armenia, it creates an impression that this is not an investment arbitration, but a commercial arbitration. What is very key here is that when we have a commercial arbitration, the disputes, at the end of the arbitration, at the end of the dispute resolution process, a decision, award is rendered, and say you bring a commercial arbitration award to Armenia, then you would need to recognize it in a court in Armenia before it can be subject to mandatory enforcement. This is not the case for investment arbitration, because the investment arbitration is not the decision is not against a specific private entity, and Armenia just has to enforce it or recognize it, but it is against the state. And the Republic of Armenia has agreed under the BIT, and by reference to the Stockholm arbitration rules, that any decision that will be rendered by the Stockholm Arbitration Institute, it is going to be binding for Armenia. A very critical mistake that is being made here, intentionally or unintentionally, is that the persons who talk about it, they don't see and they don't show the difference between being binding or being subject to enforcement. The decision of the arbitral award that now is being referred to, it is binding for the Republic of Armenia. Republic of Armenia, as a party to the bilateral investment treaty concluded between Armenia and Cyprus, as well as under Stockholm arbitration rules, which is referred to in the BIT. So here it is very, very critical to understand that as opposed to the commercial arbitration, where you would need to recognize the award before it could be enforced in Armenia. The arbitration award within the investment arbitration against the state does not need to be recognized to be binding for the country. This award is binding for Armenia. And also, I want to draw one distinction again between the commercial and investment and binding and non-binding and recognition and non-recognition. If this award were to be enforced, say, in France, then a French court would need to recognize this award because France is not a party to the Armenia-Cyprus BIT, but Armenia is a party to the Armenia-Cyprus BIT. And if we don't draw this difference, we are going to be before a very big risk that the country basically enters into a BIT, says that the arbitral award is going to be binding, and then when it comes to performing under this decision that has been made based on its agreement, it is simply going to say, oh, I don't recognize this decision, so I'm not going to perform the obligations that are rendered upon me from this decision. Just to summarize, here there is no need to recognize the decision of the arbitration court in Armenia in order for this decision to be binding for Armenia. And if this decision that is binding for Armenia is not, the Republic of Armenia does not perform its obligations under this decision, then we're basically talking about a country that does not comply with the binding arbitral award that has been rendered against it. And again, going back among other things about how the international community, how the international states, how other states are going to see Armenia after this failure to comply with the binding arbitral award. We're also sending, again, a very bad message to any investors who now will see that Armenia does not only comply with the BIT that it has entered into, but does not even comply with an arbitral award that is binding for Armenia and has been rendered according to the agreement of Armenia between Armenia and Cyprus. That's it.
That's all for tonight's broadcast. Thank you for joining, and don't forget to follow us on YouTube, Facebook, Instagram, and X. Good night.